heroes of ICE and CBC.
Pope Francis is releasing a letter to the Catholic community across the globe following last week's report of more than 300 priests sexually abusing at least 1,000 victims. In a letter, the Pope acknowledges what he calls the abuse of power and the abuse of conscience perpetrated by a significant number of clerics and consecrated persons. Actress Asia Argento is not under investigation for reportedly having sex with a 17-year-old boy. The New York Times says the leading figure in the Me Too movement settled with the boy for $380,000. Nashville police are on high alert looking for two men who may be behind a string of shootings that left 3 people dead and 2 others wounded. Tom Roberts, NBC News Radio.
News on KCAA is brought to you by Ontario International Airport. What's one of the easiest things to do in Southern California? Fly nonstop from Ontario International Airport. Now you can fly direct to Guadalajara, Taipei, and Orlando, and soon to New York. The SoCal So Easy way. Ontario International Airport. SoCal So Easy.
Wet n Wild Palm Springs is the one where you get big water park fun. Yeah, dive into all the action-packed thrills with exciting rides, slippery slides, cool water adventures, and so many ways to just chill. So get everyone together and get to Wet n Wild Palm Springs. For unlimited fun, get a season pass. Buy now, get a free ticket for a friend, and more. All for just $64.99 at wetandwildpalmsprings.com or at Food for Less. Offer ends soon. Park open daily.
Hooters smoked wings are marinated overnight, then hickory smoked low and slow, with only half the calories, so you can eat twice as many. In fact, our smoked wings are so good, you might just come to Hooters for the food. Hooters!
It's time to celebrate at Hooters, where there's no such thing as a party of one. Hey guys, I'm Blair, your favorite bartender.
And I'm Taylor, from Hooters Riverside, Moreno Valley. And we're here to get your Mondays motivated
with our great wings and delicious menu specials.
All you can eat Tuesdays and our 10-10 Wednesdays. Buy 10 and get 10 boneless wings free.
Check out our Everyday for Everybody. We love everyone, kids, moms, and cute grandpas too.
And come join us for our new late night happy hour
from 9 p.m. to closing.
Because Hooters makes you happy.
Come to Hooters, where there's no such thing as a party of one. Located with the 60 and the 215 meet in Riverside, near Moreno Valley. For more info, Google Hooters Riverside.
KCAA Loma Linda, your CNBC news station, where your business comes first.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. We were kind of hoping that there would be no verdict on the Manafort trial, so we could comment about it today. In fact, we even did a YouTube the other day to talk about it. So what's going on? What do you think is going on? Gary, what do you think?
About Manafort?
Yeah, that trial, the jury's been out 3 days now.
I think they're just going through all the facts. I mean, it's a very, I don't know what you call it. It's complicated. It's a lot of paperwork and, finances and stuff like that. It's not just like a cut and dry thing. I think they have to go through and sift through everything. And I don't know. I mean, when a jury's out this long, usually it means that there's 1 or 2 people that are, hanging on to either a guilty or not guilty verdict. So
that's true too. I had a case that went 5.5 months for the trial, criminal case, and the jury deliberated 9.5 days. So it doesn't really mean anything.
Right.
You can give up the crystal ball. I've sat through now, and one of the most difficult things for a lawyer, truly most difficult things, is sitting in the chair waiting for the jury to come back.
Oh, I guess.
When they walk into the room, you miss a heartbeat. It's really very anxiety producing.
Yeah.
But they haven't asked any questions in the last 2 days. That's significant.
Why?
Because this is a paper case. What I mean by a paper case is the witnesses almost didn't really matter. All they had were records showing whatever they're claiming happened. They didn't disclose something, and here's a document that shows the non-disclosure, and there's a corresponding document that shows that he had it. I mean, doesn't require a genius to figure that one out. There's also going to be some evidence about other documents that that he had an account or he didn't have an account or the money. The most difficult part, I suspect, is going to be tracing the money through the various sources through, they call them shelf corporations. You know what a shelf corporation is?
Yeah, it's like an offshore account, isn't it?
Not necessarily. They used to be shell accounts, which were meant to go phony.
Yeah.
Shell meaning just a pass-through.
Yeah.
But a shelf account means that somebody had set up an entity, either a corporation or an LLC, years ago and put it on the shelf. Never did anything with it, never used it, whatever, because many banks will ask you, how long have you been in business?
Oh, okay.
So what they do is they buy this shelf corporation, which doesn't do any business, but it's been around for 10 years. Maybe it paid its taxes, and maybe it didn't. You know, the normal minimum tax, for example, is $800 in California for a corporation. So you pay that, you stay active.
Right.
And so they'll have to go through all of that and trace the money through various countries and banks and places to do that. That will not be easy. If they really want to know about the testimony, and the testimony tended to support the defense, at least according to people I've talked to, they would have asked for what they call a read back.
Yeah.
There's a pretty logical explanation for that term. Read back meaning the jury has the right to ask the court to order the court reporter to read back whatever it is that the jury wanted to hear. They may say they want to read back the testimony of Gates, for example. Gates was apparently fairly well cross-examined. So that may very well be something for the defense to establish. What do they need to establish?
Oh, you asking me?
Yeah, what does the defense need to establish?
Well, I mean, that it was everything he did was legal.
No, the defense has no duty to establish anything. But the prosecution has.
Why are you asking me then?
Well, because I was hoping I was going to get that answer. No, because it's logical. It's absolutely logical.
Just being logical.
Yeah. And so what they did, by the way, in commenting about it, and I can't predict the outcome. I'm going to give you my opinion.
Give us your opinion.
I'm going to give you my opinion.
Okay.
What they did was a little unusual in that they put on no defense. Why didn't they put on a defense?
I think they didn't put on a defense because they figured that the evidence wasn't sufficient enough, and that they didn't want to give the prosecution any opening.
That's exactly right.
That got one out of two.
No, but that's exactly right, because they don't have to prove anything.
Right.
And if they can punch enough holes in the prosecution's case, what do? They create reasonable doubt. And asking for the reasonable doubt definition doesn't really say anything. I've had that happen to me many times before.
Did they have closing arguments?
They did.
Okay,
sure.
I didn't know that.
It's all in the opening and closing arguments. In fact, what we're going to do today is we're going to put into play the concept, the new concept. So I'm going to give the jury, the audience, the jury.
You, the jury
judge,
out there.
Well, actually, they're going to be the judges.
Oh, they're going to be the judges.
I'm going to give them a real criminal case that's pending in the courts right now. And then I'm going to read, because I wrote it out, because I couldn't remember all the facts in a row. I'm going to read the basic opening statement made by the prosecution. And I'll tell you what an opening statement is after I give my opinion about Manafort. I want you to think I forgot that.
Yeah, let's do that.
And then we'll do the same with the defense.
Okay.
And before we give you all the facts in the form of an opening statement, I'm going to give you a couple of principles of law that come from the law of evidence and the law of criminal procedure, so that during the presentation or after the presentation, the other side's going to object to something. I mean, I know what the something is, and I've prepared for that. And so they're going to object on the grounds that it shouldn't be admissible into evidence. And then we'll ask the audience to decide as the judges whether they should overrule it or they should sustain it. Overruling the objection means it gets in. Sustaining the objection means it doesn't get in.
Okay.
And sometimes it's a very, very key element in your case that doesn't get in and you thought it was going to. I mean, I've had cases where judges have made preliminary rulings keeping something out, and halfway through they changed their mind. All of a sudden you prepared your case entirely on the fact that it wasn't getting in, and now it's in, But the risk is if you say something is going to be put into evidence in your opening statement, and this is real trial techniques and strategies, you tell the jury what the evidence is going to show, and that doesn't get into evidence because an objection is sustained, what do you think a good criminal defense lawyer is going to do in closing argument?
Probably bring it back up.
Sure, he's going to say, remember the district attorney said they were going to prove ABC. Did you hear that? I didn't hear any of that.
Yeah.
And the opening statement is a promise. They're telling you, they're promising you they're going to do this.
Yes.
And they didn't do it.
Right.
And so what does that mean for the credibility of the prosecutor? It means they don't have any credibility because they said they were going to do something, and you milk it.
Yes.
I mean, I really have milked it.
I bet.
But I did it in a civil case when the guy made all these promises that he couldn't keep any of them. And I stood there and said, did he promise you that? Did you hear that? I didn't hear that.
It's just like ammunition for you.
And it absolutely is. And so when you're a trial lawyer, even if you're the prosecutor, you got to be careful what you're going to tell them, because many times you don't know in advance. Yes, there's something called a motion in limine, Limine. A motion in limine is something that the judges will determine before the trial begins. You're saying, I want to bring this into evidence. The deputy district attorney wants to do that. The defense says no. They submit briefs, and the court decides whether it's going to get in or not. Then you know. So when you take your opening statement, you know not to say something that's not coming in.
I mean, isn't that logical to do that before the trial starts?
Yeah, but things change. Number one, it's it's very fluid, and some judges will say, you know, I'll decide that when it happens.
Take that under consideration.
No, they'll say let's put it on and we'll see what's happening.
Okay.
And
during the trial?
Yeah. And you know, in case you're also wondering, what happens is you have what they call a bench conference. You go to the side of the bench, to the sidebar. That's right. And you talk about all those things, and you have a court reporter taking down everything that's being said, because that becomes part of the official record. And there, nobody's supposed to be hearing it, although people have loud voices and the jury's not that far away, but, you know, presumably they're not hearing it. And the judge will make a ruling at that spot. And you go back, and if you lost, you're smiling. You know, you don't want the jury to think that you lost.
Right.
You know, oh, hey,
do you ever
what a great result. They're going to hang him.
Hey, do you ever speak a little louder so the jury can hear?
Nah. That's somewhat inappropriate. But the truth of the matter is there's all kinds of what I call shtick involved in a trial. Everybody's doing their own thing. Everybody has their own strategy. Everybody decides how they want to present it to a jury. And we'll talk a little bit about my opinion right after the break. And let's see, by next week, we'll probably know the answer. We will probably pretty definitely know the answer.
KCAA. Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system, so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work, so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
I love that music. Every time I hear it. Great talent. The guy that wrote that has great talent.
Oh, I thought you were talking about me.
You have a great talent in a different place. But before I talk to you about Manafort, let me just say that after each side presents its case here and the objections are ruled upon, I will then make the ruling. And you can see members of the audience whether you agree or you don't agree. You don't have to agree. And many rulings are what's called discretionary, meaning a judge can do pretty much what he or she wants to do, and it's rarely reversible on appeal unless there's what they call arbitrary and capricious with no basis, or that the judge abused his or her discretion. So we'll have that. We'll talk about direct and circumstantial evidence and how it fits in. And then for the finale, well, not the finale, kind of the quasi-finale, I'm going to ask the audience to decide whether or not the defendant is guilty or not guilty.
Okay.
So they'll be the judge on two rulings of evidence, which I'll explain in advance, and they're going to decide the case. And that's our new concept, which we're calling what? You be the judge.
You be the judge.
That's it, audience participation.
I like it.
So it's just, this is the first time we're trying it.
Okay.
And I welcome all your comments. You know I'm reachable at judgeherb@gmail.com.
Ask Judge Herb.
Ask Judge Herb.
Ask Judge Herb.
You'd think I'd have this right by now.
At gmail.com.
I keep getting this wrong.
It's all good.
Anything dealing with the computers gets me confused.
The computer. Let's not talk about the computers.
Okay, I won't. So now let's talk about Paul.
Okay, Paul Manafort.
Paul Manafort. My prediction,
Sir Paul.
Come on, do the drum roll. Let's do the drum. There you go. Is they will find him guilty on some, they will find him not guilty on others. There'll be no clear-cut victory for the prosecution. In other words, getting a conviction on all 18 counts, which I don't think they ever expect to do anyway.
No.
And I don't see the jury letting them walk unless they feel, and I don't know all the evidence, so it's a little unfair for me to give an opinion. I don't know what the jury got, what the jury saw. I'm only relying on what I've been told was presented to the jury, which were these documents.
Right.
And what they meant. I asked, actually, I listened to a program where they talked about what documents they were. And so I had a chance to evaluate, well, what would I think if that was the document that was getting into evidence at the time? And in a paper case like this, many jurors will trade because they want to go home.
Right.
It's nice that they're spending as much time as they are. They should do that. And I've told a story about I had a horrible jury that just wanted to go home, didn't think about anything.
Yeah.
And said so because we got an investigator afterwards, and they said so.
Well, look at
OJ.
OJ.
Go home.
Look at OJ.
Going home.
Please.
So.
So you
what
think
happens,
he's going to be found? So you think he's going to be found guilty on some counts and then not guilty on others? Do you think he'll be reprimanded? Do you think he'll be released on bond, or do you think that he'll have to go straight to jail? Do you think they're going to keep him in jail?
Well, you don't go straight to jail.
Well, he's already in jail. Well, he's already in jail.
Yeah, but he's there as a hold prisoner. He's not there as a convicted prisoner. He's there because there's no bail.
Well, he did tamper with a witness.
Well, that's why he's sitting where he's sitting.
All right.
I think it's a matter of, I think it'll probably depend on what the outcome is. If the jury finds him guilty on one count and not guilty on 17,
then
he might give him he might give him bail.
Okay.
He might give him bail anyway.
Right.
Because this is going up on appeal.
For sure. Right. Yeah.
And that's why there have been comments made about the way the judge has been handling some of the evidence that's being presented. Apparently, the judge has reprimanded the prosecution several times in front of the jury.
Really?
Yeah, said, don't do this, or scolded them, or whatever it is. And some rulings got in, which I thought were a little questionable. The one that gets me is, why is the $2,500 jacket relevant enough to be considered in this trial? What difference does it make? Nobody's saying he didn't have any money.
Right.
I think it's prejudicial to the defendant.
I mean, he had to have some money. He's been an advisor or part of the Republican National Committee and worked for Reagan and all these guys for years and years. So, I mean,
isn't that?
But I'm saying he's not broke. It's not like he just walked off the street, and came into the Trump campaign. He's been a part of this for years.
On the other hand, the judge gave that one to the prosecution because I'm sure there was an objection.
Yeah.
On the grounds that they wanted to show that he had the financial ability, and he knew he had the financial ability, and he had the financial resources, and he knew he had them because look at how he spent it.
Right.
And that's one of the elements of one of these white collar type cases.
Well, like he bought season tickets for the Yankees and spent like $200,000 and used one of those shelf accounts that you said to purchase them.
Well, look, these guys and gals who have been doing this for centuries, They figured out the ways, and they don't ever figure they're going to get caught.
Right.
That's why they have multiple layers. One corporation bought a share into that one, which is a special voting share. And they're the lawyers, the Wall Street type lawyers, are clever. They figure out all these tax ramifications or whatever. But sometimes these people get greedy and sloppy and think they're going to get away with it. And boom, the axe falls.
Yeah.
If this was a guy practicing in Des Moines and wasn't doing much of anything, nobody would pay attention to him.
Right.
This is going on every day in many, many ways. If they wanted to look into Wall Street, they could keep the courts full for a long, long time.
Yeah.
Bottom line. So let's get to the show.
All right, let's do it.
Okay, so anyway, there'll be two separate instances. Remember, I said this is an actual criminal case. It's ongoing. So an important rule to remember is that the prosecution must prove their case beyond a reasonable doubt.
Okay, so this is a criminal case.
Yes, you out there in the audience have to think about that.
Okay.
Because that's all pervasive when it comes time to making an ultimate decision. And I always tell jurors this. I must have told it every single time I've ever tried a case as a defense lawyer. And that is, on the verdict form, there's only two blanks. One says guilty and the other says not guilty. And I always ask the rhetorical question, why isn't there a blank for innocent? Because the defendant doesn't have to prove any innocence. The defendant could say nothing, which is basically what they did here, and rely on the prosecution failing to meet that burden. So you got to check off the box, not guilty. Not because he didn't do it,
right?
But because the prosecution didn't prove it. In fact, a public defender friend of mine, I once asked her, I said, how can you represent some of these? And I used some nice rhetoric for that. And she said, I'm representing the system. The prosecution has to prove its case beyond a reasonable doubt. The defendant has nothing to do with it. It's a question of whether the prosecution did what they were supposed to do constitutionally.
Just keep it in check.
She had no problem with it.
Yeah, well, keep it in check.
Well,
there's got to be checks and balances.
Well, that's where we're going with all the political decisions that are being
made
right now.
That's what I'm saying.
In fact, there is a move afoot right now to continue to limit the checks and balances, because there is an effort to say that there aren't any. And that's what you see right now. So I talked to you about the two verdicts. So here's the case for the people. I wrote it down, true facts. I changed a couple of names because I thought it would be better to do that.
Yeah, don't use my name.
Let me get my pen for that one. Juror number 6, Garver. Out. Too opinionated. Or no opinion.
No opinion. No.
So anyway, the bottom line on Manafort is I think they'll probably convict him of half, and they'll acquit him on half. And it doesn't really matter, as I said last week, or I said it on the YouTube, because sentences run either consecutively or concurrently. Concurrently means they run together.
Right.
In other words, if you're sentenced 3 times to 3 years, you don't do 9 years. You do 3 years.
Yeah.
They're all combined.
Right.
Consecutive is you add them on. And you hear some of the heinous crimes. You got 3 life terms consecutively. Okay. You ain't going to make it past the first lifetime consecutively, but at plus 20 years. They always do that kind of thing. So ultimately, he's probably facing the same sentencing, assuming he's convicted.
Right.
Whether they convict him of 2 or 5 or 10.
Let me ask you an opinion on this. All right, so let's say he does get convicted. By the way, and I know you know this, Judge, and I do too, that this is not the only trial he's got to face. He's got to go through another one. I think it's a federal one, right? It's different, or is this?
I think that one is in D.C.
Is it in D.C.? Okay, so I
think so. I'm not really sure.
Yeah, so he's got to go through another trial. This is just part one of his mess that he's got to deal with. Do you think, personally, that if he gets convicted, do you think Donald Trump, President Trump, will pardon him? What's your gut feeling?
No.
You don't think so?
No. That's just a personal opinion.
Okay, I'm just curious.
First of all, never before the midterm elections. This is a guarantee. Whether he does it after, and remember, if any of these cases or charges are state cases, the pardon power doesn't apply. So if the Washington, D.C. case deals with state law in any way, or the District of Columbia law, there's nothing to pardon him from.
Okay.
It's the same thing for Cohen.
Right.
who's probably singing like a Boyd right now.
Well, I know he ain't going to pardon Cohen. That ain't happening.
You know what?
I think he's going to
Nothing would surprise me.
I'll tell you, I think he's going to pardon Manafort. If Manafort gets convicted, I believe he will pardon Manafort.
On what basis?
Just his rhetoric, man. I mean, you hear where he's coming out and says, Paul Manafort's a great person and this is a witch hunt and blah, blah, blah and all that. So, I mean, he's setting it up for it. That's all.
Well, you know, there was a discussion, and I had some input to it, that it's improper for anyone to comment about an ongoing trial if you're in a position of power and say which way you think it should go. That's attempting to influence the jury. That's not a nice thing to do. I'm not talking as a legal or illegal or anything else, but it's frowned upon by anybody to comment about an ongoing trial. We're not allowed to comment about an ongoing trial. Did you know that? If we're on the bench and in a case is going, we cannot discuss that case at all. But when it's over, different story.
Right.
And you cannot comment on anything. And in fact, anybody does comment, it's grounds for a mistrial.
Right.
Jurors will come in sometimes and say, you know, I was watching TV last night and I saw, well, no, you can't sit and watch TV. People will say, well, why weren't they sequestered? Not sequestering very much anymore because it's expensive, number one. And people have access to so many things. It's kind of like an illusion to do it. And this is not a major case, believe it or not. It has major political implications.
Yeah.
But this is not any different than many, many cases that are prosecuted every single day in every courthouse in this country. So let's get on with the case.
All right. Yeah.
All right. Dr. Bill Jackson, an MD with a practice in a small inland empire city, was working for Dr. Carolyn Phillips, also an MD. They were also lovers. In March 2012, Dr. Jackson bought the practice from Dr. Phillips. The building was also owned by Dr. Phillips. It went into foreclosure when Dr. Phillips went into default. Dr. Jackson bought it from the lender, ABC Financial Company. In July 2012, I'll tell you after the break.
All right.
What happened in July of 2012?
Okay, cool.
Many things.
All right, cool. Hey, listen, if you want to ask the judge any questions, you go to Ask Judge Herb. Email him, askjudgeherb@gmail.com. Also, check out his YouTube videos, Judge Herb Dodell, and his book, From the Trench to the Bench, Amazon.com. Right?
Right.
Okay, we'll be back after this. Just making sure, Judge.
Oh, you're doing a great job, Gary. You'll be a great juror.
Yeah.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, we're back. So anyway, in July of 2012, a water damage loss occurred at the building. Dr. Phillips had an insurance policy to cover the damages. And by the way, Dr. Jackson is the defendant in the criminal case. So you can differentiate between Dr. Jackson and Dr. Phillips.
Okay.
In November of 2013, there was a burglary at the office. A claim was made by Dr. Jackson and was paid. Medical equipment, computers, and some furniture artwork was stolen. Remember, in July of 2012, Dr. Jackson bought the business and the building. In January 2014, there was another water damage loss. Dr. Jackson, now the owner of the building, made a claim for the damages. He engaged a remediation company, ACE Remediation, to repair the damages. He also engaged an insurance adjuster, Bates, to assist him with the claim with the insurance company. So you got the picture so far. The prosecutor is now saying, here are the facts behind the allegations that are now going to come. And so the loss, this water damage loss, was caused when the flapper, I love that term, to the toilet was maneuvered and paper towels were stuffed in the toilet to cause it to overflow. On March the 24th, 2014, see, we're taking this chronology because it's going to become very important.
Okay.
Someone broke into the office through a window. A claim was made to the insurance company. Significantly, on March the 26th, 2 days after the broken window, an arson fire destroyed the property. There is a videotape of a person approaching the building just before the fire and leaving after there was an explosion. A Toyota Tercel was noticed in the area. The allegation is this belonged to an employee of ACE, the remediation company. A claim was made to the insurance company for the fire damage, a portion of which was paid. Dr. Jackson is the insured, and they're blaming him for, number one, the arson, and for committing acts of insurance fraud. Bruno, the guy who worked for ACE, who had been reported as an employee of ACE, was arrested and charged with multiple counts of insurance fraud. The people will introduce evidence to support its version of the facts, and the defendants will do likewise. The people will prove that Dr. Jackson, because here's the case coming right now.
Right.
The people will prove that Dr. Jackson, Ace, Bates, and Bruno, what a great group, conspired to make fraudulent insurance company claims going back to the July 2012 water damage claim and including the damages from the March 26, 2014 arson fire. That's the crux of the criminal case. They claim that Dr. Jackson was in bad financial condition, having borrowed money from Wells Fargo to buy out Dr. Phillips, and had been unable to sell the property when the business was failing. Dr. Jackson did not have a business license and was behind on property taxes. He reported to his alarm company that he had received notice of proposed power outages from the DWP when the DWP records did not support it. ACE participated in the scheme so they could get the repair or rebuild jobs. Bates was in it for the fees that he would earn as a public adjuster, and Bruno was instructed by ACE to set the fire. He also had 2 additional water damage claims to his own property for which he made claims. The causes of those water damages were identical to the water damage that was sustained in January of 2014. There are cell phone records from Dr. Jackson to Ace and vice versa, from Bates and even Bruno before the fire, showing connections with each other. And so, that's it. That's the plan. That's the prosecution's case.
Wow.
You got any questions before we start?
I'm just wondering. So Jackson had contact with Bruno? There's phone records of that?
He did have contact with Bruno, but it was after the fire. We'll get to that when I talk about the defense position.
Okay, but
that's right. That's good. That's what I want you to do. I want you to ask questions.
I'm asking. I'm just asking. I mean, as a juror, if I'm a juror right now, I just was curious about.
Okay, but the problem for you is there's no porn stars or any drugs involved in any of this. You're going to have to reach up into some other place.
What's that supposed to mean?
Well, I would like to spice it up with some porn stars, but because I know that's what you were doing for all those years.
I'm not doing it. Listen, what do you mean? I used to go to court with my dad all the time, man. My dad dealt with this stuff all the time.
You're a juror here. You're going to be the judge.
I am.
In fact, I'm going to ask you to raise your hand when we get to the 2 objections.
Can I use my middle finger when I turn off?
I don't know how to take that.
I'm joking, Judge. I'm
not lying down.
I'll give you the peace sign.
Okay.
I'll raise my hand and give you the peace sign.
Okay. Right. Well, what do you think? Now if you're sitting in the audience right now and you just heard this opening statement, It sounds pretty convincing.
Yeah, it sounds like this is a pattern.
Yeah, that he burned it down.
Yeah, that
and he set the water and everything.
Well, I mean, especially the financial problems with didn't pay the property tax, and he was having the business was failing and stuff like that. He's trying to get a way out. He can't sell the property. So yeah, that comes into question right there. And then you got the whole scheme with everybody making money on the arson fire.
That's your first blush. By the way, I mentioned this, I know, during one of the shows. The University of Chicago ran a study asking people whether they made their decisions up, at what point they made the decisions up. And 95% decided the cases based on the opening statements. That is a very serious thing to do. When you're a lawyer, you better be prepared to make an opening statement that's got some punch to it, number one.
Yeah.
Doesn't promise too much, promises what you're going to deliver, and summarizes it, even though you're not supposed to summarize it in an opening statement. You always preface it by, and the evidence will show. Then it gets past the objection.
Right.
So that's the people's case.
It's pretty strong.
And by the way, the people are referred to as the people because in a criminal case, the parties are the people of the country or state or county versus the defendant.
Yeah.
In a civil case, it's Jones versus Smith and stuff like that.
Individual.
So they're all called for the people. Now, the defense.
Okay, let's hear it.
Remember, no burden of proof, right?
Reasonable doubt. Got it.
Reasonable doubt. Okay, there was no conspiracy, and there's no evidence to support the requirement of proof that the parties were getting together, planning to commit an illegal act, and starting the process. No evidence. What I read to you before and what the judge will tell the jury every time is what the lawyers say in opening statements is not evidence and cannot be considered to be evidence. It's what the lawyer thinks is going to happen. So what the defense is, there's no evidence of anything. The evidence will show that Ace, Bates, and Bruno were unknown to Dr. Jackson in 2012 or 2013. Dr. Jackson was not a policy holder at the time of the July 2000 water loss and received none of the proceeds. They all went to Dr. Phillips. The insurance company listed the claim as fraudulent, the water damage claim, the first one. Supposedly, it was a water backup. The insurance company referred the claim to its Special Investigations Unit, also known as SIU, as a suspicious fraudulent claim. Remember, this is a claim made by Dr. Phillips years earlier. It ended up paying a six-figure claim to Dr. Phillips. With respect to the burglary in 2013, there was a burglary in 2013 in November. It was discovered that the property stolen in this burglary was found in Dr. Phillips' office in Southgate, where she had moved. And there were witnesses to establish the fact. So the stuff that was stolen ended up in her property.
Oh, wow.
And Dr. Phillips had sued Dr. Jackson and was preventing him from selling the building. At one point, she had to be removed from the building by the sheriff. The January 2014 water loss was not caused by Dr. Jackson. There is no evidence that he did anything. A few days earlier, he had engaged Ace to complete repair work done by a prior contractor. They were to meet at the building a few days later to discuss the job. The evidence will show that once Dr. Jackson discovered the water loss, that's when he engaged Ace. At no time prior than the date of the discovery of the water loss had Dr. Jackson met or communicated with Ace, and he had no contact with Bruno. According to Ace, Bruno was not an employee. He was the equivalent of a subcontractor. Dr. Jackson also had no contact with Bates, the public adjuster, who had been recommended to him by Ace, and it was after the water loss. Therefore, obviously, couldn't have been involved in 2012 and 2013. The first time Bates ever spoke to or visited the building was on January 7th, 2014, which was after the loss had occurred. This is confirmed by Bates' handwritten notes made at the time, and as part of his business records, it was an accurate reflection of what had happened at the time. There's no evidence regarding the break-in. Both Ace and Bruno had a key, so they could continue to perform the repair work from the prior water damage loss. The only expense was to board up the broken window. It was paid by the insurance company. Dr. Jackson's agreement with the lender on the building, ABC, required the lender to pay the property taxes. This can be seen from the loan documents. When Dr. Jackson found out they were in arrears, he paid them. He received notices from the DWP, and that is why he called a security company that there were going to be power outages. As to the March 26, 2014 fire, Dr. Phillips lost a motion in her civil case against Dr. Jackson on that same day. She had sued Dr. Jackson, and Dr. Jackson was resisting it, and Dr. Jackson won an important motion on that day, the very same day that the fire took place.
Wow.
She was not happy. There were more than 40 lawsuits against her at the time as well. The fire took place on the same day, as evidenced by the court's minute order, a copy which will be shown to the jury. The cell phone records reflect conversations from before the fire relating to ACE's continual work on the building. Permits had just been issued. Conversations after the fire were normal once there was a report of a fire. The evidence will show that the insurance company is behind this because they wanted to recover what they had paid and not pay the balance of the claim. It is in the insurance company claims department file notes that they were intending to go back to try to get their money back. Even though there were at least 2 other suspects with regard to the fire, no meaningful investigation was conducted. The insurance company has refused to provide certain records pertaining to its investigation and has redacted some records, although they did provide them to the prosecution. There's no evidence, direct evidence, to tie Dr. Jackson to any of the others. There's a reasonable explanation for all the people's claimed facts. And that's the answer there. That's the defense position. You got any questions about that?
Sounds like they are having a lover's quarrel, and Dr. Phillips was very upset about losing, and
she stole her own stuff.
She stole her own stuff. I mean, she reported it stolen. She stole her own stuff. She lost the claim on the same day the fire happened, which is sort of too much of a coincidence. Dr. Jackson didn't have any contact with these contractors or anything before with all the other previous stuff. So I have to say that Dr. Jackson definitely has reasonable doubt there.
Okay, now you got to go back to when I told you the facts. I mentioned that the first loss was in July of 2012.
Right?
And the first burglary was in 2013. Right? You got that?
Yeah.
Okay. Now, according to the public adjuster who was accused of being a participant in this conspiracy, he didn't meet anybody till January 7th of 2014.
That's what I'm saying.
So how could he be accused? Because he was accused. The prosecution has now alleged that he's part of this.
Yeah.
How could he have been part of it if he didn't know anybody?
That's what I'm saying. I mean,
So that's one of the things that we're going to get to. Now we're going to get to the objections right after the break, and I'm going to tell you what the 2 objections are. Maybe we'll get to a third one, and we'll see where we go with that.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, audience, you now have all the facts, even with the additions from Gary. So you know pretty much what each side is saying. And of course, you always have to remember, and I tell this to people, I still tell this to every court that I'm in, it's about the burden of proof. So keep that in mind. Now what we're going to do is we're going to get to a couple of objections. The prosecution wants to introduce evidence of a July 2012 water damage loss. They want to introduce evidence of a burglary in 2013, and they want to introduce the lawsuit between the parties, and they offer it as evidence of the fact that if he did it before, he being Dr. Jackson. If he did it before and he was involved in these things before, it's likely that he did it again. And it's really basically it's an attack on character. And character evidence, and I actually went back and looked at a law school book that I kept. A little moldy, but I kept it. And this has been a fight going on for many, many years. There is an absolute rule, and I'm going to give you the section in California, and you can always Google it if you're somewhere else, because it's pretty much the same everywhere that you're going to find, maybe some slight nuances. It's section 1100 of the California Code of Civil Procedure. 1101 is the one that we're really looking at. And basically says you can't do it. You cannot, if you're the prosecution, you cannot bring in evidence of a defendant's character unless, and there are some exceptions, and here's the exceptions. The evidence is admissible that a person committed a crime, civil wrong, or other act when relevant to prove some fact such as motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or accident, or whether the defendant in a prosecution for an unlawful sexual act, that's not applicable. And so the question is, does it get into evidence? The defendant's argument is, number one, there's no supportable evidence that anybody knew anything about the 2012, at least the defendant, knew anything about the 2012, 2000, or whatever, and that it would take a lot of information and a lot of assumptions. Now, there is an exception. I just read the exception. If you can show a common scheme and plan, in other words, like this guy, Bruno, there were like all these water damage losses caused by the same thing.
Right.
The flapper was up and the toilet was plugged with paper. That might get in because it shows a common scheme and plan.
Yeah.
A common practice.
Continuing
That's
to do
the
it.
one that comes under the code section 1101B that allows that kind of evidence in. So the prosecution is claiming they're entitled to support their case with it, common scheme and plan, because that's what they're claiming. And the defense is arguing not so, and there's not insufficient evidence to get to that conclusion. What's the ruling?
Well, I mean, I would.
Audience, what's the ruling?
Are you asking me or the audience?
I'm going to ask you. Well, you are the audience.
Oh, that's what I'm saying. I mean, you're looking at me.
I'm going to ask you to raise a hand. I can't help looking at you.
Here's the peace sign. I didn't give you the peace sign.
You didn't give me the other side.
No, the peace sign.
But the bottom line is that the audience has to decide, does it get in? Look, it's obviously prejudicial to the defendant. It's highly prejudicial.
I would say it doesn't get in.
Even though if it comes in, you can cross-examine it.
Yeah.
You can show, and that's what I meant.
You're talking about Jackson coming in for Jackson,
right.
Not Bruno. For Jackson, I would say for Bruno, yes. For Jackson, no.
Well, Bruno is not a defendant.
Okay, well then I'm just saying, it sounds like
the question is, does it get in or doesn't it get in?
I say no. I say it doesn't get in because that's a defamation of his character, and he didn't have any knowledge of it in 2012. There's no proof of him knowing anything. He had no contact with any of these guys. I'd say no. That's because that would, like I said, defamation of character.
What if the prosecution had said they were going to prove that in their opening statement? What do you think the effect of that would be?
Well, I think that would be probably if the judge sustained the objection. I think that would be bad for the prosecution.
It'd be horrible for the prosecution.
Right. So it's
the theory of the case.
Exactly. So I'd say it would be really bad for the prosecution if it didn't get in.
Remember, we're talking about a conspiracy here.
Right.
And a conspiracy requires two or more people to get together to plan a criminal act and start something to have that criminal act effectuated. So there are all these foundational issues. Now, the difference between direct evidence and circumstantial evidence. Direct evidence is, I'm looking right at you. That's direct.
Yes, you are.
Circumstantial evidence are facts you have to find to get an inference of something happening. I used the example probably last week about the jam on the kid's face.
Right.
And the refrigerator door being open and the jam was taken out of there and open. That's circumstantial. Circumstantial evidence is like a link.
Right.
Chain, like a link chain.
Like a chain.
And if one of the links in the chain is significant, I'm not talking about insignificant, and you fail to prove that, or something to the contrary is proved, what happens to the chain? Breaks.
Yeah.
Chain breaks, can't get to the end.
Right.
You got too much of a gap in between. So these are all circumstantial evidence type questions. If you can get it in, you can argue you're getting it in for the purpose of showing that a clear, reasonable inference is the following, and use that. But if you lose that, a good defense lawyer is going to be right there. They claimed that he burned the building down, but ladies and gentlemen, he was in Chicago at the time.
Right.
And you want to argue that somebody did it for him or whatever, but you got to have evidence for that.
Yeah.
You can't do anything about that. It's even an analogous to a situation I had in court where a lady was seeking to set aside a default judgment against her on the grounds she was never served. The process server said, "Oh, I served her at her house, and I walked over and I gave it to her." She brought in her passport and the receipts from the airline coming and going. She was in Paris.
Yeah.
And so, those kinds of things, when they fall out, they fall out.
Yeah.
And so that's why you got to be extremely careful. One of the things I tell all young lawyers, don't oversell. The more complicated you make it, the worse it is. The best cross-examination is one question, if you can get away with it. And it's a leading question. Isn't it true that you murdered him? No, I never did that.
No, I didn't do it.
But so the second evidentiary question, I hope you all took notes and made your ruling. So, Gary, you say it doesn't get in.
I say it does not get in.
Okay. Now, the next piece of evidence is the argument that the prosecution made that he didn't pay the taxes. And since he didn't pay the taxes, that means he was in terrible financial condition. His answer was, it wasn't my obligation to pay the taxes. It's in my trust deed with the mortgage company, and I thought they were paying it like an impound account.
Right.
And when I found out, I paid it. My business was not great, but it wasn't that bad. So when they offer the testimony from the mortgage company that the taxes weren't paid, and the objection is that I wasn't supposed to pay it, the objection is going to make it that it should be excluded because it's not relevant. Not relevant. And not only is it not relevant, but there's a section in California, and I'll give you the code section number because you got to find them in every other state. This is section 352, and what it says is the court in its discretion may exclude evidence if its probative value is substantially outweighed by the probability that its admission will, one, necessitate undue consumption of time, or B, create substantial danger of undue prejudice, or of confusing the issues or misleading the jury. So this is what the judges can do. Say, you know what, it's going to take us a half a day to go through the tax records and the trust deed and the lender and everything else. And what's the real significance of it? It's prejudicial if it was to come in that he didn't pay the taxes. Forget about the records from the mortgage company. Just that should not be allowed to say he didn't pay the taxes. And so, because his argument is, it wasn't my obligation to pay the taxes. It's another issue, right?
Right.
How relevant is it? In the scheme of things, given the facts that you've seen in both cases, how significant is that fact? They're going to say he didn't pay the taxes, and he's going to say I didn't have to.
I think it's pretty relevant. I think it is. Yeah, I do, because it'll show some sort of financial strain, regardless. If he did pay the taxes, why doesn't he just say let it in? And say, hey, I paid the taxes, and does he have receipts for that?
That's the alternative. If the judge overrules the exception, overrules the objection, then he can get it in.
I would say that that would be something that should come in. You know what I mean? I would have that evidence come in, because I like to know if he had to pay the taxes, if he had receipts for paying the taxes, things like that. That's something that, as a juror,
it's about relevance.
Yeah, it's about relevance. I like to know if it was relevant as far as like his financial situation was.
So then the statement in the opening comment by the prosecutor was accurate.
Yeah.
He didn't pay the taxes, but he didn't tell you, ladies and gentlemen, that he didn't have to pay the taxes.
Right. So
That's
I'd like to know.
the defense response to that.
Yeah, I'd like to know.
Okay, the third one, we have a little time to get to the third one.
Okay.
And I read it in because I wrote it out last night.
Are you going to tell me if I'm right about any of this stuff?
I didn't give you the notice of the rulings yet. I'm going to do that before the day's out.
Okay.
But remember I said that Bates, the public adjuster, made notes that he was there on January the 7th?
Yes.
And he made those notes, and he's going to testify about it. Objection, hearsay. prosecution says it's hearsay. It's an out-of-court statement that he was there on January the 7th being offered for the truth of the matter, even though he's here.
I would overrule that. I'd like to know what Bates has to say. I'd like to know what's going on.
But the objection is hearsay. It doesn't matter what you'd like to know.
But I mean, he's part of the whole process.
It qualifies as hearsay, but it qualifies as an exception to the hearsay rule.
See, I was right. There you go.
The hearsay rule has an exception for what's called business records. Business records.
All right, yeah.
Business records.
I know. That's what I'm saying.
He made a business record at or about the date. That's what I read it in.
Yeah.
At or about the date that it occurred. On January 7th, he was making notes.
Yes.
It was true and accurate at the time that he made them. And his custom and practice was always to make notes of all of these meetings.
Keeping a ledger.
So therefore, keeping track.
Right.
That's right. So the answer to the 3 evidentiary issues, number 1, you keep out the prior acts. I would sustain the objection to that.
Okay.
For all the right reasons. Unless the defendant puts up character on the offense, the prosecution cannot attack him on character.
Okay.
But if the defendant says, I'm the greatest guy since sliced white bread, the prosecutor has an opportunity to bring in people to say, no, you're not.
Right. Okay.
That's what happens there.
I dig it.
The second one, on the question of relevance, 352, I suppose I'll let it in. So you were right. I'll let it in.
Overrule it.
The third one, I overrule the hearsay objection.
3 for 3!
Are you what? If you're not doing anything next week, I know there's the jury. They're looking for a jury in Van Nuys. Okay, but now we're now at the end. The people have now heard some arguments, really,
right,
made by you. I tried to not give you any arguments or tell you how I'm feeling about it. But given the facts that you have, and assuming these are all the facts, what would your verdict be?
I would
now.
Oh, go ahead.
We have the audiences out there.
All right.
If you think that he's guilty, raise your right hand. Yeah, don't be so quick. If you think he's not guilty, raise your left hand.
Oh, there you go.
Simon says.
Right.
Okay.
Left hand.
Okay, well, I'd be interested if you guys out there want to let me know what you think about the rulings on the evidence. Number 1, this is audience participation.
Yes.
And the second is what you think the outcome is. Keep in mind, what are those magic words? Beyond
a reasonable doubt. Ask Judge Herb at gmail.com.
This is the new concept.
You can email the judge. Ask Judge Herb at gmail.com. Give him your guilty or not guilty verdict. Judge would love to hear about it, right?
I would.
Okay, ask Judge Herb at gmail.com. Great show, Judge. I love it. I was on.
I like the concept, too. I really do, because it gives the people a chance to participate.
All right, we got to roll out.
Okay.
All right.
See you next week.
Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.